All right, court is calling 2019 CR 8528, State of Texas versus Arthur Scarborough. Could I have parties announced for the record for the state?
Michael Villery off the state.
Matt Stolhansky from Mr. Scarborough.
And are you Mr. Scarborough? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Arthur Scarborough who was placed on deferred adjudication in 2019 CR 8528 for the offense of aggravated sexual assault of a child on March 28, 2022 for a period of 10 years? Is that you?
Yes.
State?
Violated conviction number 13B on or about the 24th day of August 2022 in Bexar County, Texas. The defendant, Arthur Etoku Scarborough, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant failed to comply with the instructions of Lone Star Offender Treatment Program, his court-ordered sex offender treatment program, and that the defendant was suspended from sex offender treatment for failing to admit responsibility for his offense in violation of condition number 13.
How do you think to that? True or not true?
True. And the state would waive and abate the remaining allegation.
Did you understand by pleading true to violation of condition 13B, court could find it true, grant the motion, find you guilty, and sentence you to life in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to 13B?
Yes, Your Honor.
Court will find 13B true. Is there an agreement?
There is not, Your Honor.
All right, state, what are you requesting?
So this is a case where I think Mr. Stolhansky would like to present first, potentially, because it really part of our argument is going to depend on the potentially new willingness to admit certain culpabilities. And so, from the state's perspective, if he's willing to take some responsibility, that might lend itself to him being continued on probation with some type of like ISF. But if he's not, then the issue becomes for us is what do we do with this person who is not willing to be rehabilitated and cannot be in our community without being rehabilitated?
I don't believe ISS will accept him.
Probation, the sex offender, the SOMU that was their original recommendation. So I think they would, based on that, but the court is much more knowledgeable on those aspects.
Well, we're all open to learning things. Probation, if you can look into that. And defense, do you have a witness to call?
Yes, Your Honor, I do. I would call Mr. Scarborough.
All right, can you raise your right hand for me, please?
He just pled true, and that's a massive moment in Texas. Pleading true to a probation violation is basically handing the judge full power to sentence you anywhere within the original range, including life. The real question now isn't guilt, it's whether the court believes he's capable of rehabilitation.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record. All right, you're going to need to speak up.
Arthur Scarborough.
All right, defense.
Hold on. Is the microphone here? Was it better if I put it here?
No, just everyone just speak up.
Mr. Scarborough, you understand why you're here?
Yes.
Okay. And the at the the polygraph, they said that you denied liability or culpability. Is that correct?
Yes.
So did you ever deny that this thing happened?
No.
Okay. And tell the court what your thinking was.
At the time, I didn't want to believe that it happened. But I accept 100% responsibility, not partial responsibility. I accept 100% responsibility.
And so it was about who instigated the start of this.
Right.
Because when you took your polygraph, you said that she was as much of an aggressor as you were. That's not true.
That's not true.
And that you were I
was the aggressor, and I accept responsibility for that.
And that was the reason that he was expelled from the program.
Right.
State, do you have any questions?
So I just want to make sure that I'm clear and I'm understanding is that you reported initially to your sex offender provider that this was unwanted and not provoked or initiated by you. Do you remember telling her?
I,
You did say that.
yes,
And are you telling this court now that that statement is not true?
that's not,
Okay, that you did, that this was wanted and that it was provoked by you?
Right.
Okay.
I've had a lot of time to think it over, especially while I was incarcerated for 61 days, and then I'm on house arrest for the 35 days. And I realized that I am the one that's at fault.
Okay. Do you remember having a conversation with your sex offender provider, Ms. Vicki Elliott, and her giving you that opportunity to say the truth?
Yes, and at that time, I didn't want to believe that that was the truth.
And isn't it true that when she confronted with you about this and letting you know that you'd be exited from the program and that you would potentially have an MTR, that you still at that point decided that you weren't willing to take responsibility?
I did take responsibility, and I told her at that time that I accept 100% responsibility. But I still stuck to the story that I wasn't 100% at fault as the aggressor. But I realized after thinking it over for so much time that I'm 100%.
Okay. But you also
I accept the responsibility, and I wish to continue the truth.
and you understand there's a distinction between, it's not really taking responsibility to say that a child provoked this, right? That's not really taking responsibility. You understand that? So when you said initially you took responsibility, that's not really taking responsibility.
When I talked to the counselor after I felt the part,
I'm sorry? I can't hear you.
when I talked to the counselor after I failed the polygraph test, I did take 100% responsibility.
Okay.
But for her, that wasn't a good enough answer.
Okay. So you're still, you saying that it happened, but that the child provoked it and that it was
No.
unwanted is taking
No.
100% responsibility.
No, that's not.
Okay.
I accept 100% responsibility. The child did not get responsibility.
I'll pass on this.
Any other questions?
Pardon?
Any other questions?
I just want the court to tell the court about your health issues that we're dealing with.
My health issues, I have a terminal illness called cystic fibrosis that affects my lungs, mainly my digestive system and sinuses. I have chronic sinusitis.
Which is why you're wearing the mask.
Yes, I can't be around. I'm real leery of germs. I have ulcerative colitis, and I have obstructive sleep apnea, where I have to be on a CPAP machine. All of those things that I didn't get the proper medications and things like that when I was incarcerated. And I don't want to go through that again.
And other than that one violation, you're behind a little in the money because you didn't pay while you
While I
were.
was incarcerated. Yes.
But other than that, there are no new offenses.
No new offenses.
And that you are the transportation for your mother.
Yes.
And your mother goes to the doctor, hospital, at
Sometimes,
least once a week.
a couple times a month, to the pharmacy as well, to the, I think, for grocery shopping. She's going to be 88 years old in a couple months. I'm the primary caregiver, which I've not been able to do for the last 95 days since I was locked up and in a house.
And she lives on your street
She lives 100 yards from me, but I can't go and see her
because of the monitor.
because of the monitor, house arrest. And I'm the one who takes care of her. My sister has had to take off work and suffer financial loss because of that.
All right, anything else?
One further question, Judge.
Yes.
Did you have cystic fibrosis when you committed this offense?
Yes, I was born with cystic fibrosis.
Okay.
The genetic terminal illness.
I have no further questions, but I just wanted to make the court aware that Ms. Vicki Ellie is here. If the court has any questions for her, as far as probation is concerned.
All right, would you like to call Miss Elliott? Defense?
No, ma'am.
Okay. All right. Any other witnesses from either side?
No, ma'am.
State, what are you requesting?
Judge, I'm going to request that this court revoke his supervision at this point. You've prosecuted cases, you have defended cases. I think this is a clear case where he still is. He's saying, "Well, I took."
And there it is, the prosecution framing this as a community safety issue. Notice the strategy. If he won't accept responsibility, they argue, he can't be treated in sex offense cases. Accountability isn't just moral, it's legally tied to eligibility for continued supervision.
100% responsibility afterwards, but that's just not the case. That's why we're here. That's why he pled true, is that he didn't take responsibility. And that there is the inability at this point for the state to do anything other to ensure that our community is safe from him potentially reoffending. And that would be to place him in a corrections department so that he can't have access to children. This is a case that, obviously the state recommended initially, but that was, the court's aware that we do that in certain circumstances due to victim cooperativeness and really in times taking into consideration the further well-being of victims. I think he was given an opportunity. He continues to not take this seriously or make good efforts in progressing his treatment. And so we're going to ask the court to revoke his community supervision and sentencing.
All right, defense, what are you requesting?
And Your Honor, we're asking that you leave him on probation. He's done 60 days in jail. He's been on monitor for 30, house arrest for 30 days, 30 something days. That he completely admitted today in open court that he was the aggressor, wasn't the child's fault in any way. I'm not sure what the state was speaking of when he said he's not accepting responsibility. He's telling you that he did it, and he admits he did it, and it was his fault. And, he had time to think about it in jail, and that this is 100% responsible for this, and it's his fault. I would ask you to leave him on probation. He's committed no other offenses. He's been a pretty good, other than this one thing, pretty good probationer.
All right, is there anything else for me to decide?
Nothing further to say.
All right, the court is going to grant the motion, find you guilty, sentence you to 10 years in prison, give you credit for any time served, Chapter 62 registration, no contact with the complainants, showing you what's entitled trial court certification of defendant's rights to appeal. You do have a limited right to appeal, and that is as it relates to the allegation in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck to you. All right, who's here? Michael Tello or Teo? Is Tello? Oh, wow, I see people confuse me with the double L's. All right, so what is happening with this case?
Your Honor, if the court recalls, last year, at the end of last year, I was trying to get in touch with 88 Groomer because he had been on vacation and sick. And then I found out that Mr. Groomer stepped away from the prosecution trial division. And then Mr. Sanders took over that positions. And unfortunately, I think Mr. Sanders has left the office. And so that was right before the holiday break. And last week I reached out and spoke with Mr. Escobar, who was the OVPA from the carryover. And he informed me of who the new first and second chairs were. And I spoke with Mr. Garahan today. And the purpose of the reset last time was to allow me to speak with the prosecutors to see if we could come to an agreement. I understand that Mr. Garahan has not completely immersed himself in the file, which is understandable. And we would ask the court for just a little bit of time to allow Mr. Garahan to become familiar with it so he would feel comfortable in making a decision as far as a plea offer.
All right. And I will tell everybody that I empathize and I try to sympathize. But my first day as a prosecutor, you know what ended up happening? I showed up to the 379. The files were brought down to court by Miss Ferguson over there. And you know what the judge says? Family violence. You're going to trial. This is your case. And you know what I said? Oh, which case is this? And I'm like, okay, we'll do it.
I understand.
So what I will do is we'll recall this.
This is the turning point. He's shifting his story. Earlier, he implied the child provoked it. Now he's claiming full responsibility. But here's the problem, courts. Don't just look at what you say, they look at when you say it. Is this genuine reflection or courtroom damage control?
For the week of Norma, is that a true story I just told?
Yes.
So there's no doubt.
Oh, I believe.
All right. We're gonna recall this, Ms. Ferguson. Can we recall this for the week of the 16th?
Of this month,
Yes.
the 17th, the 16th is the holiday.
Yes.
Yeah.
A holiday / celebration.
That's right.
So it'll be the 7th.
All right, State, will you be able to make an offer by that time?
Yes, Your Honor. I am not fully immersed in the case, but I am familiar with the case and the extent of how many cases that the individual has. So I will be able to extend an offer by then.
All right, so we'll be back on the 17th, and at that time, the state will give you an offer. And it will be a quick turnaround for a plea deadline date, okay?
Yes, Your Honor.
All right, thank you. Is there any discovery issues still outstanding or no?
Not to our knowledge.
All right, just do the acknowledgement of discovery. If one hasn't already been done, I think it may have.
I think it has.
All right, thank you.
Thank you.
All right, and is there a prosecutor available?
Yes, I'm present for the state of Texas, Your Honor.
Thank you. All right, court is calling 2022 CR 9877, State of Texas versus Francisco Hasso. Could our parties announce for the record?
Yes,
the state?
Travis Rodriguez for the state of Texas.
Defense. And are you Mr. Hasso?
Francisco Medina Hasso.
Is that who you are?
Yes. Yes.
And we have an interpreter here. Could you raise your right hand for me, please? Do you solemnly, not you, sir. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you may lower your hand. Could you state your name for the record?
Vicky Cavazos Jones.
Counsel, do you speak Spanish?
I do.
And do you speak it fluently?
My first language. Very fluent.
And have you been able to review all of these documents with your client in Spanish?
Yes, I have.
Mr. Hasso, all of the documents that we're going to discuss are in English. Were those documents reviewed with you in Spanish?
Yes.
And
Yes.
did you understand those documents?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Hasso, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on count 3 of the indictment. That is a 3rd-degree felony, and waive and abandon the remaining counts.
Any objection? Mr. Hasso, did you review the document with your attorney entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions?
Yes.
Did you understand in count 3, you're charged with the offense of possession of child pornography? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that if you have a plea bargain agreement with the state, the court does not have to follow that plea bargain agreement? If for any reason the court does not follow that agreement and gives you more than you bargained for,
The state just made its core argument. We can't ensure safety. That's powerful. In probation revocation hearings, the burden isn't beyond a reasonable doubt. It's much lower, so the judge doesn't need certainty, just enough to believe supervision failed.
The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hasso, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, were you aware that your client is not a U.S. citizen?
Yes.
Has he had a chance to review this plea with an immigration attorney, or did you advise him?
I advise him.
Mr. Hasso, has your client informed you of the immigration consequences of entering a plea in this case?
Yes.
Did those consequences include deportation, the denial of naturalization, and not being able to re-enter the United States?
Yes.
Did you understand the consequences of entering a plea in this cause number as it relates to your immigration status?
Yes.
And knowing those consequences, do you still wish to go forward with the plea?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. According to the plea bargain agreement, state is proceeding on count 3. Punishment is to be assessed at 4 years in the prison. There are no applications. The state is taking in consideration the following cause numbers: night mag number 671041, 671043, 671040, CM number 101289, and there's lifetime registration. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes.
State, is that the plea?
It is the state's understanding, Your Honor.
Did you review the paragraph with your attorney entitled waiver of appeal paragraph? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes.
Counsel, have there been any such motions?
There have been no motions.
Then Mr. Hasso, to count 3, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. The state has previously tendered States Exhibits 1 and their attachments to opposing counsel. At this time, the state offers States Exhibit 1 and attachments to the court pending any objections.
Without objection.
Mr. Hasso, did you review the documents entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
10 years, not life, but still a decade behind bars. This is what happens when probation collapses. Deferred adjudication can feel like a second chance until it disappears in a single hearing.
Yes.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Strong.
Anything you wish to say on behalf of your client?
Yes, sir.
Court will sentence you to 4 years in the prison. Take in consideration nine bag number 671041, 671043, 671040, CM number 101289, and Chapter 62 registration, and no contact with minors. Is there anything else from either side with regards to sentencing?
Your Honor, I do have some physical dismissals to present to the court whenever the court's ready. May I approach?
Yes. And did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, thank you. Thank you so much for coming down. All right, the court is calling 2022 CR 1765, State of Texas versus Robert Bell. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
Defense?
Adrian Bettis for the defendant.
Are you Mr. Bell?
Yes, ma'am.
Counsel, have you received all the discovered in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bell, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on the lesser included offense of aggravated sexual assault of a child.
Any objections?
No objections.
Mr. Bell, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on aggravated sexual assault of a child? That is a first-degree felony. The range of punishment is anywhere from 5 years to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of aggravated sexual assault of a child. Punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine, no applications. They will take in consideration, everyone please whisper. They will take in consideration JN 2082555. There's to be Chapter 62 compliance, no contact with the complainants or any minor children. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense of aggravated sexual assault of a child, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offers State's Exhibit 1 and its attachments and evidence.
No objections.
Showing you what's entitled waiver of consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did
ma'am.
you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. After reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
No, Judge, we're requesting a PSI.
All right. We'll just need a PSI and a top evaluation. Ms. Ferguson, I need a date. All right, we'll come back on January 26th. On January 26th, I'll let you know what the court's decision is.
Thank you, Your Honor.
You're welcome.
Pause right here. This is huge. For non-citizens, a plea like this doesn't just mean prison time. It can mean automatic deportation and permanent bars from reentry. Sometimes the immigration consequences are harsher than the sentence itself.